Thanks very much. Trademark practitioner, as Julius said, and my practice mainly focuses in advising on the protection of brands, clearance and protection of brands, and managing portfolios. We do a lot of dispute work as well, but in that advisory piece, distinctive character is so fundamental to what we do that when I was asked to do a talk, I thought I'd focus on that. I think there's going to be another session on acquired distinctive character, so possibly. I'm seeing possibly rather than maybe I'll do one. But I thought we'd focus on inherent distinctive character. So really what makes a trademark a trademark. And so that was the idea for this talk. Fundamentally, what is a trademark? And a lot of the cases talk about this and talk about various different things. They often talk about badge of origin, the fact that the trademark functions to guarantee quality. Mostly, the definition comes back to the fact that it's able to distinguish the goods of one undertaking from those of another. That's what you hear all the time. And that's kind of used as a sort of fundamental definition of what a trademark does and what it is. Another comment about it that is always referred to is Jacob's comment in Treat that the mark allows the consumer to repeat the purchasing experience without education. So in terms of inherent distinctive character, they're able to see a mark and repeat that purchasing experience without having been educated that that is a mark in and of itself. So my point is actually the distinctive character of a mark, it's inherently distinctive if it's able to do these things in and of itself without a business having done anything with it, without that business having used it extensively, without that business having told its consumer set that that's what the mark is. And because that's basically the fundamental point, the fundamental issue in relation to what a trademark is, it obviously impacts on pretty much everything, in my view, to do with both the protection of it and then ultimately the enforcement of it down the road. Things are distinctive or they aren't distinctive, but how distinctive something is obviously impacts massively on all of the downstream discussions around whether you can or can't protect, and if so, how far can you protect a trademark? And that's what we spend a lot of our time advising on, and what I spend a lot of my time arguing with the Intellectual Property Office about. So, fundamental concepts, trademark law. It's what allows registration. So most of the time when you're looking at the UK Trademarks Act and looking at trademark infringement or the Community Trademark Regulation or the Trademarks Directive, you're looking at whether a mark can be registrable or not. There are lots of provisions around that. Fundamentally, is the mark distinctive? Is it able to inherently distinguish the goods of one party from another? Or not is the key factor in being able to register it. It's one of the key factors in then impacting on what I've put here in some of the issues that come downstream in relation to the enforcement. So Sable and Puma, which probably everyone is very familiar with, is the case, one of the fundamental cases that looks at likelihood of confusion, and at least one, probably several more, of the factors that that case tells you to take into account when assessing likelihood of confusion is whether and how distinctive the mark is, both from an inherent point of view. So how inherently distinctive is it? It doesn't distinguish between whether something is very inherently distinctive and so whether something has become very distinctive through gaining a significant reputation on the market, through use of the mark, etc. Median is also a fundamental case in relation to the interpretation and analysis of marks and the comparison of marks, and it also focuses on various aspects of distinctive character in the comparison of these two marks, comparing, depending on how you analyse the case, the dominant distinctive elements, or whether a particular element has an independent distinctive role within the mark. All of these things come back to the same fundamental principles, which is kind of what I'm talking about. So I'm using these provisions from the UK Trademarks Act. I'm only really focusing on the main provisions. There are lots of provisions around registrability of trademarks, But the fundamental ones in relation to whether a mark functions as a trademark, a word mark, the normal trademarks that you see day to day, these are the main provisions. They have equivalents in community trademark regulation and obviously flow from the Trademarks Directive, but for these purposes I'm looking at the wording of not the wording, but the sections from the UK Trademarks Act. So for these 4 fundamental provisions in relation to distinctive character, so from a law point of view, what do the UK IPO look at as to whether a mark can be considered inherently registrable? These 4 provisions. Section 31A, understood as being, well, this mark simply is not capable of being a trademark. So this is different from it just being non-distinctive. There are no circumstances under which this thing could function as a trademark. So often that objection gets raised where the mark isn't even defined properly, it isn't a point, maybe it's a description, maybe it's something which isn't intended to be something which can function from a trademark point of view, or it could be something that is so simple that no matter what the owner or the applicant does with that mark, it could never function in a trademark sense. A full stop, maybe. Something over simple. That provision doesn't really get used an awful lot. You don't see it used very much, but fundamentally it's a fundamental bar. You don't need to go beyond this point. Don't pass go. You're done from a registrability point of view. B, C and D, the main provisions that get looked at in relation to distinctive character. 31B effectively says the mark isn't distinctive. This is kind of circular in the sense that you need to know what that means in order to apply the provision, and it's a catch-all, because really almost every other objection relates to whether the trademark functions as a trademark or not. And whether it functions as a trademark or not is fundamental to whether it's distinctive or not. They're kind of intrinsically linked. And so a 31B objection can be raised really in relation to any mark that doesn't function to indicate or guarantee origin of the goods. Come back to that. 31C, often referred to as the descriptiveness provision. If a word is descriptive, then it can't function as a trademark. It should be objected to. If a mark is descriptive, it will always be non-distinctive from a relationship of provisions point of view. But there are plenty of marks that are non-distinctive without being descriptive. And descriptive, that provision is referred to as descriptiveness, but actually the wording is quite specific, exclusively designates a characteristic of various aspects of the goods and or the creation of the goods and or the provision of those goods. And exclusively designates is something that's been looked at quite hard as to what that really means. But ultimately, is this thing descriptive or not, is where that provision lies. D has become the common name in trade. It's, I would say, generic. So the classic example is something like escalator, which very much was a trademark when it was introduced, is very much not now. Because of the way in which it's been used, because probably, almost certainly, the owner of the mark didn't enforce rights in it properly. It's become the name for that product rather than the name for their product. And that's the distinction between it becoming generic or not. There are loads of things, actually, that we would say Biro is another one, which was very much a trademark when it was introduced, but quite difficult to imagine now that it ever was. So that's D. In our life, arguing with the UK IPO about whether marks are registrable or not, the examiners at the UK IPO usually find, if they find use of a term, they'll say, oh look, this term's already being used, it's almost certainly generic or non-distinctive because it's being used. And that's the sort of double-edged sword of the internet to a certain extent. You can pretty much find use of almost anything if you try hard. And so actually we spend quite a lot of time arguing around why that use doesn't establish that this has become the common name. That provision is not about it being used by other parties. It's not. They could be using it in a trademark sense. It's not even about other parties using it descriptively or in a generic sense. It's about whether it's become the common name. The fact that certain people are using does not mean that that is the case, if that makes sense. So if something is the common name in trade, again, it's always going to be non-distinctive. So from an interrelation of provisions point of view, if someone's raising a section 3.1d objection, then a 3.1b objection will always be relevant too, but not the other way around, if that makes sense. I've mentioned the proviso. The proviso to the section is from an inherent, insofar as these things aren't inherently distinctive, you can overcome the objection by showing that because of the use made of it, the mark has become distinctive, which I'm not going to talk too much about because I think it'll be dealt with hopefully in other sections. I've put have a break, have a Kit Kat as an illustration. Have a break. The whole have a break case was around whether Nestle could establish that have a break was distinctive through the use that it made of it. And a lot of discussion around use made of it on the basis that actually they never used have a break. At the time, they never used have a break on its own. And that was often that even if consumers recognise have a break as a trademark now, was it as a result of the use made of it? Or was it as a result of use made of that? And it's a lot of discussion around that, and case law coming out of the fact that you can use more than one trademark at a time, and the have a break functions as a trademark in itself, etc. Very important case in relation to distinctive character, particularly acquired distinctive character, which of course I'm not talking about, fairly obviously. The interesting thing about, I think, one of the interesting things about trademarks and distinctive character is fundamentally trademarks are all about how a consumer perceives a particular word or how a consumer perceives a particular mark, and whether they see it as a brand, whether they see it as something which is indicating a particular party or not. Of course, rights in the trademark only exist insofar as they can be defined within the statutory provisions. And so it's kind of this, I think, interesting tension between actually distinctive character being defined by a set of provisions as to what isn't registrable, and distinctive character really being about what a consumer sees and what he understands that word to be doing in the context of the material that the owner of the mark is using. I don't know if that makes sense. And there's a real tension, in my view, between that. What I will try and get across is I think what the current legal position is in relation to how words are interpreted as to whether they're distinctive or not, and how I think that doesn't necessarily match how a 2014 consumer would really understand those things. So I think they're different things. So ultimately, a lot of these issues about registrability and about distinctive character come down to whether the mark conveys meaning or not. Some marks are arbitrary. Where a mark has no relationship, where a word is made up and has no relationship whatsoever to the goods or services being offered under the mark, it's arbitrary, then there's effectively an assumption that it will be seen as being inherently distinctive. Google is an example. There are loads. Kodak is often given in this as the example of the sort of ideal made-up trademark. Well, it doesn't mean anything, or it didn't mean anything. You could argue Google might mean something now, but that's a battle for them to have, and a battle over size. But it didn't mean anything. Now, really, people assume, therefore, that, well, from a consumer's point of view, I guess the idea is that when you see that word being used, what else can it be doing other than being a brand? It doesn't make sense. There's no other reason for it to be there. And so this isn't really discussed, by the way, from a case law point of view. It's just like, well, that's obviously inherently distinctive. It has no meaning in relation to the goods. But ultimately, really, the question is why? Well, the reason is it's arbitrary in relation to the goods, so a consumer seeing it has no other explanation for it being there other than the fact that it's a brand. So, but that applies in relation to other types of marks. That analysis should be the way in which these things are looked at in relation to other marks as well. Most brand owners want to convey meaning with their brands. Google's a great brand, but to get people to understand it and know what it is, you've got to have quite a lot of scale and quite a lot of effort to get people to understand what that brand means, what it stands for, who you are, So most people, in our experience, we have people coming to us and asking us to clear new brands and advise them on distinctive character. Most people are coming along saying, "Oh, I'd like my brand's going to be, I'm doing a law journal. I'm going to call it the Law Journal." Oh, that's amazing. I can see that a lot of effort went into that. I can see that. There's a slight problem, which is you can definitely use it. That's the good news. The bad news is, why would that function as a brand at all? But most people want their brands to do that. They want the brand to tell the consumer what the product is. The best brands convey the meaning, but do it in a way that people still perceive it as a brand. The problem is drawing the line is very difficult. So most look to convey meaning about the product, and whether the mark is inherently distinctive depends on how that meaning is conveyed. That's my view. Most of the case law looks at actually, is there meaning in these words? Is that meaning relevant in relation to the goods and services? How closely relevant is it? And therefore make a decision as to whether it is a trademark or it isn't a trademark. The UK IPO position in relation to descriptiveness, that's C provision, but it applies really in relation to analysis of B objections as well, so non-distinctiveness objections as well, is descriptive means conveys a clear and unambiguous meaning. So if I have an immediate understanding of what this mark conveys, and that meaning is relevant to what the goods and services are, then it's descriptive. And I think that's the UK IPO are probably a little bit more liberal about that interpretation than a court is. I think the courts are even stricter about, well, this doesn't function as a trademark. Look, it has this meaning. But look at a couple of examples. These are a couple of examples of well-known unusual juxtaposition. Baby dry. Baby dry, I'm sure you know as a case. If you don't, it was a very big case for trademark practitioners on the basis that this was an analysis, not of that mark actually, although that was the only representation of it I could find, just of the word mark baby dry and whether it was inherently registrable. And that case found that it was inherently registrable, despite the fact that you got a fairly clear impression of what it was trying to do. It's a nappy. It might be trying to keep a baby dry in some way. It's not Google, is it? But it was felt that, well, it's not the usual way of referring to these goods, and the fact that it's not saying it's a dry baby, the fact that you can use this phrase in a longer sentence and make it sound descriptive does not mean that it itself doesn't function in a trademark sense. Unusual juxtaposition found to be registrable. Now, most practitioners and courts say, well, it's just wrong. That clearly isn't distinctive. I personally think, I think if you're a consumer, I don't think there's any, whilst that conveys meaning about the product, it doesn't do it in a way which exclusively designates the product. There's something in it. It's not very distinctive, but it is distinctive. Double mint, slightly old-fashioned picture of double mint there. Double mint is a well-known case. The arguments around distinctive character were, well, actually, no one knows what double mint really means. It could mean any number of things, or at least two different things. It could mean twice as minty, it could mean two types of mint. And on that basis, it doesn't convey a clear meaning, it isn't descriptive. And the court found, well, if one of those meanings works from a descriptive point of view, then it's willful foul of that descriptiveness provision. It is descriptive if any one of the possible meanings of the mark are relevant to the goods or services. Do you think double mint functions as a trademark? I mean, you probably, if you've come across it, you probably do, but then it's difficult to differentiate it from the fact that Wrigley's have made a lot of use of it. But do you think it does inherently? If you had quadruple mint, synctuple mint, it's kind of odd, isn't it? Slightly unusual. From a consumer point of view, would you see that and think, that's just telling me there are 5 types of mint in this product? I just don't think you would, from a consumer understanding point of view. But from providing some relevant meaning relating to the goods, the tribunals or the courts will tend to say this isn't distinctive or it is descriptive, clear and unambiguous meaning. How does the mark convey meaning? we've just been talking about this to a certain extent. So my question there is this how consumer perception works? I think that's definitely how the legal analysis works. And of course, trademarks only exist, the rights only exist insofar as they can fit within that legal framework. They're not a piece of physical property. They can only exist within that framework. So unfortunately, we're stuck with that. And probably to be fair, most practitioners would agree with that position. But ultimately, to me, surely it must be about how a consumer understands that mark when he's first hit with that mark, with that word. If the presumption about Google is because it's unusual, it doesn't fit, there's no other explanation for it, then that analysis can apply in relation to marks that are much closer to the line, that do convey meaning, despite conveying a meaning that might be relevant. So I put the dig-a-lot spade. So this is an argument I've had with the appointed person about registrability. It's not about the mark dig-a-lot. But in relation to a spade, the mark dig-a-lot, I feel as a consumer, you see that, you go into B&Q and look at a dig-a-lot spade, you'd think, well, that's not telling me what this is. Why is that there? That's unusual in the context of the product. Probably not exclusively designating a characteristic. I mean, arguably you could say, well, it does. I can dig a lot with the spade. But really, would I not think that was a brand in the context that I think I would? The problem with that is, does it convey a clear meaning in the context that's relevant to the goods you dig with a spade? You can dig a lot with a spade. Maybe it's a good spade, maybe it's a strong spade, I don't know. And the problem is almost certainly not registrable. Almost certainly a court would say that isn't functioning in a trademark sense. And I guess I'm drawing the distinction between the two. I think a consumer would see that as a mark, and it makes sense to have it protected. Context, question mark, useful comment. The other thing that happens that I think is a clear further tension between consumer perception of a mark and the possible protection of it is the fact that a mark can function very well as a trademark in context. So when a brand owner uses the mark and uses it in a certain way in relation to a certain product area, it can function very well in a trademark sense. But from a protection point of view, the analysis is really more about whether it's possible for it to be used in a descriptive or non-distinctive sense, rather than the applicant actually using it in a brand sense. Does that make sense? So if it were possible to use a mark in it descriptively, then almost certainly an objection would be raised, or a court would find that mark to be descriptive and therefore not registrable, at least not inherently distinctive. And again, I think a lot of the analysis on that, you hear a lot, an honest man shouldn't require a defence to an infringement. This feeds in, I think, to the analysis of distinctive character in relation to trademarks. So if it's possible for someone to use that mark innocently and or descriptively in any context, the courts and the UK IPO don't want to grant a monopoly in relation to it, because even though that innocent party would have a defence to infringement if they're using it in a descriptive way, for example, and they're operating in accordance with honest commercial practices, section 11, they shouldn't have to seek a defence because they're innocent in any case. To me, that reasoning is very odd. You wouldn't need the defences if that wasn't going to happen, because the defences have built in the fact that you're operating in accordance with honest commercial practices. But I think it does feed into the analysis of distinctive character quite a bit. So that's why the analysis is not necessarily about exactly how that applicant is using the mark and whether a consumer sees it as a mark, but how anyone could potentially use that phrase or that word. And it creates a different situation, if that makes sense. Visual addition, so words that aren't necessarily distinctive. We get this question all the time. It's like, well, the law journal, I get what you're saying, it's not the best distinctive mark, but my version is purple, so it's fine. Again, not great from a brand choice point of view. even if you were able to obtain a registration of this thing, the scope of protection around it will be very narrow, because obviously you can't stop people using the words law journal. But this gets analysed a lot. Actually, even if the word is non-distinctive, what about the presentation of that mark makes it look like a mark? Again, tension between, I think, what a UK IPO or a court will say and what I think a consumer would understand. To me, does it look like a trademark? It's kind of circular as well. What is a trademark? Is it distinctive? But as a consumer, look at it again and think, well, coming back to that Google example, well, why is it looking like that? What's it doing there other than indicating origin? This UK IPA practice is a very long, very boring practice on this type of thing. Best Buy is the case, which was basically Best Buy non-distinctive, presented in a sort of yellow label, found background font. These things won't help you, generally won't help you. And there's a fine distinction between adding distinctive elements or not. Ultimately, if you're having to obtain a registration by adding some form of presentational aspect to it, it's not going to be a very strong brand from a legal protection point of view. It might function perfectly well because the marketing guys are telling you that, or telling the corporation that actually this is perfect for our consumers. But from a legal protection point of view, it will never be very broad. I raised these two cases because they're both Richard Arnold and they're both on distinctive character. The bottom one is around an inherent registrability issue. Now is also, I mean, to a certain extent, although it's a much wider case, and you're probably familiar with, it's a fairly recent case on infringement passing off and registrability. I raised the two because I think his reasoning in the one clearly flows into the other. Sun-ripened tobacco was a case when he was appointed person before he was a judge. And does everyone understand what the appointed person is? So the appointed person is an appeal body from the UK IPO. So if you're applying for a trademark registration, it gets refused. You can appeal that decision in two different directions, one to the High Court and one to the appointed person. The appointed person is usually a senior QC in IP. There are usually 5 or 6 of them. Jeffrey Hobbs and various people. Richard Arnold, who's obviously now one of the main IP judges, was an appointed person for some time. And he made a decision on this. Sun-ripened tobacco was being applied for in relation to tobacco, which may have been ripened, and the sun may have been involved. They're obviously, from a word point of view, this is not a trademark. The case is all around whether that as a whole functions in a trademark sense. Do you think it does? No? So he finds, from my point of view, I say that sun, I don't see why that sun isn't distinctive. Why would it not be? Yes, it's a picture of the sun, but it's not a generic picture of the sun. How would you define a generic picture of the sun, I guess? You might say, well, maybe it is. And that's where the argument would be. I don't think a sun looks like that, personally. I haven't seen it look like that. Not in person, anyway, although I haven't met it, I guess. And of course, there's argument around that. His point was, well, actually, that's a picture of a sun, and all that does is reinforce the descriptive meaning of sun-ripened tobacco, therefore the whole is non-distinctive. The problem with that from an analysis point of view is, well, so I'm an airline, and I can't have a logo which depicts a plane functioning as a brand. That's difficult. The end point of that, whether that's right or not, the end point of that argument, I think, is odd. Now, the argument in Starbucks and Sky, he actually got really quite cross about this issue in this case. And, being one of the main IP judges, that's kind of important to understand that the main judge is being cross about a particular issue. That was the mark that was registered, that mark now, with that particular stylisation. So he found in first instance, and the Court of Appeal confirmed, that now that mark was devoid of distinctive character, doesn't function as a trademark in relation to TV, particularly on-demand TV. And the analysis goes, well, it's on demand, so the whole purpose of that service is that you can access it whenever you want. You can access it now. And the presentation of it doesn't add anything. so it's non-distinctive. The Court of Appeal confirmed and said that's fine, that's right. And also said, well, all it's really doing is indicating a characteristic of these services. It's indicating the nowness of them. That well-known nowness that we all have in relation to our TV. I had a hearing earlier this week where we were talking about this, and I said, do you think I could register nowness? And there was a quick conversation. It's like, why not? It's a bizarre thing. I know what you're trying to get at when you say nowness to me, but you're sort of saying immediacy, but you're alluding to it. It's an unusual way of saying it. And so for me, from a perception point of view, it's unusual. The point is the court will look at it more and, well, now is not a word that should be monopolised by anyone. Its meaning is relevant in relation to an on-demand service because it is immediate and now immediate, basically the same thing. You shouldn't be monopolising this. And so no registration. The presentation, all it is a font and some lines. This is nothing. Go. Non-distinctive. And so the case on trademark infringement disappeared. There's no case. Passing off case didn't work for various other reasons. And I don't know, in the concept, I watch a lot of TV. I'm pretty sad about that stuff. If I saw that as a brand in relation to a channel, I would think it was a channel. I don't know what you think. Not much inflection, no one's saying no. It's obviously a borderline issue. See, the interesting thing for me is I think the right legal analysis to say, well, consumer will perceive that as a trademark, but the scope of protection for it is going to be very limited. It doesn't. If it's registered on the basis of its presentation alone, and you don't agree with me that now could function as a trademark in the context of a TV service, which I think, but then I spend my life arguing that for clients, so I probably am a little bit biased. But even if that's not right, that presentation, that looks like a trademark to me. Now, but the point is, though, that the scope of protection would be very limited, because I can't stop someone just using the word now, and suddenly it looks different and it's presented differently. Then it's probably the distinctive elements of the two marks from a comparison point of view are not the same. So he doesn't need to find that invalid. All he can do is find it valid, but say, well, Sky's mark looks totally different. No one would be confused, because no one would assume a connection only on the basis of the word now. The distinctive character of the mark lies in the presentation, and the presentation is different. So I guess I'm trying to draw a distinction between what I think a consumer perception would be, which I think is very relevant to how brands work, and how a court would interpret it.
Do you think there's a Julian argument that wouldn't say, I'm watching Now TV, like in the normal conversation?
I agree. Well, you're on my side. Why would you say that? I'm watching TV now is a descriptive phrase, but like you can say, well, this product's designed to keep my baby dry. That doesn't make Now TV or Now not a trademark in the context of the goods. If you're using that word innocently and descriptively, you don't infringe anyway. If that makes sense. I'm moving on. I know there's not a lot of time. I've put shapes and colours in, and I've got 9 bullet points on my slide, and all of them are questions. Which maybe because there isn't a clear position in my view. So the things I wanted to raise, I'm really raising them more to think about, is fundamentally, the directive indicates that trademarks can be lots of different things. Words, logos, shapes, colours, sounds. Sounds happen quite a lot. Intel, McDonald's, there are loads of sounds registered. Function pretty effectively, they're quite easy to register actually. Smells, they're not easy to register. In fact, they're basically impossible to register. But shapes and colours, to me, from a 2014 consumer point of view, are becoming more and more important in a cluttered market in relation to brands, people trying to find other ways of distinguishing themselves from other people. Shapes and colours, I think consumers are more aware to now than they were before. People are trying to register them more. Obviously, there have been lots of fights, mainly between Nestle and Cadbury, about shapes and colours going on. So the question I'm raising is the bar the same height? So when you're looking at distinctive character, is it the same analysis in relation to a shape or a colour as it is in relation to a word? Now, broadly speaking, generally the courts will say yes, theoretically the bar is the same height. because there's no reason to say it isn't. But does a consumer perceive a shape in a trademark sense in the way that he does a word? So actually, if the answer is no, and I think most tribunals would say that's the case, i.e. the automatic presumption, unlike with Google, is not that this is functioning as a brand, then you've got to work harder to persuade someone that this is a trademark. So really, fundamentally, from a theoretical legal bar is the same height, but the practical one is higher. Harder to educate. Can these things ever be inherently distinctive? They're all mainly questions. For me, the main one is, why is an arbitrary shape different from an arbitrary word? Now, this shape is obviously Kit Kat. I say obviously. I fairly obviously eat a lot of chocolate. This I know as a Kit Kat. Would everyone recognise that as a Kit Kat? Yeah? That's a pretty utilitarian shape, so I can understand why that wouldn't be regarded as inherently distinctive. But where a shape is arbitrary in relation to the goods, Casper's here, we're arguing about turtles all the time for an American client that sells turtle-shaped stuff. And the product is a constellation light. It doesn't need to be turtle-shaped, but it is. That shape is arbitrary, really, in relation to the goods. Is it inherently distinctive because of that? Our counsel on our case doesn't think so. We do. But we're perhaps on that particular side of that argument. I think the point is, the distinction is drawn also in these cases, and if you've read the Kit Kat cases that have come out initially from the UK IPO, Alan James, who's the most senior hearing officer at the UK IPO, and then Richard Arnold referring the questions to the European courts going on at the moment, a distinction is drawn between people recognising the product and understanding that the shape is a trademark. And that is a very difficult thing to understand, in my view, from a distinction point of view. So the surveys on this found that if you showed someone that shape, they'd say, oh, that's a Kit Kat. That's a Nestle product. Or even if they don't know that it's a Nestle product, they'd recognise it as a Kit Kat. And so obviously the argument from Nestle is, right, so that shape, that's the only way they've identified the product. There's nothing else on it. That's how they've identified a specific origin of the product, so it's a trademark. Alan James says, yeah, but I don't know, I get they recognise the product, but I don't know they recognise that that shape is a brand in relation to the product. And that's what's being looked at, from then Arnold then referring these questions. That distinction is a very difficult one, because actually it's always an assumption. It's always an assumption that a consumer will see these things as a brand. Even for Google, it's an assumption based on certain things. So I appreciate I don't have a lot of time, but I wanted to raise this as a question, if that makes sense. On enforcement, these two cases I'm really just raised these cases to sort of show, I think, how the courts don't necessarily really understand this issue very well. So and again, these two cases are the same judge. In the first case, it's a passing off case, not a trademark infringement case, but the principles in relation to distinctiveness are the same, and that's the mark on the right, fox and boot. And it's a picture of a boot and a picture of a fox, and it's a mark relating to fairly high-end shoes. And it's distinctive, but it was a mark that was created in the 18th century. Yeah, looking at Chris. 18th century, and used in relation to bespoke footwear. A small British company that made shoes for Fred Astaire and all these sorts of people, and they had lasts for an individual person's foot, etc. Still the case that you can go and spend £5,000 on a pair of shoes that are fitted to your foot. And in the case, actually that mark was chosen because there was a fox hunting market, and they made boots. So they had a picture of a boot and a picture of a fox. And so in the judgment, the judge is saying, basically this mark says old-fashioned English craftsmanship, it says quality, it says these various things. And said on the basis of that, it communicates those things clearly. On the basis of that, it's very distinctive. And it is distinctive. I mean, it's not, a clear way of communicating that. But actually him finding that as having a very high level of distinctive character was a key part of going down the line to the decision he made. In relation to shoe boudoir, the same guy says, in relation to the comparison of the marks of shoe boudoir, this mark, the other mark was boudoir by desire. The word boudoir is a familiar word, elusive both to the idea of dressing up and to a certain ornate aristocratic style. So quite a similar analysis, not non-distinctive, but it communicates certain ideas that are relevant to the product in the way that this other mark did. And the same guy finds that as well, so that's a really weak element, not sufficient to find confusion. This is not very helpful for you, but I'm more highlighting the fact that it doesn't seem to me to be a very well understood issue, which, considering how fundamental it is to the interpretation of marks and to the understanding of whether something can be registered or not, and not finish my sentence, it doesn't need finishing. Just very briefly, well-known marks I've touched on. Whilst a well-known mark is always distinctive because of what the owner of the mark has done with it, how inherently distinctive the mark is impacts very heavily on what the owner of that mark can do. The more inherently distinctive the mark is, the easier it is to keep a margin around that mark, to enforce it in areas of use that are totally unrelated to the owner of that mark. I've used Google and Intel. Google as being a very distinctive mark, Intel as being something that you clearly know and is well known and is very well known, but because of the nature of the word Intel, can be used in a lot of other marks without it causing a link. So I've said impact on, where is it? Does the inherent distinctive character impact on such marks? Impact on due cause, impact on establishing link. Pretty much if someone uses Google or Boogle or Dougal or something along those lines in any field, it would almost certainly bring to mind Google. And that's not just because it's the biggest mark in the world, maybe Apple, but because of the nature of the mark, because it's very unusual in the context. Whereas Intel, you add another letter to that or put it in a word, actually you might be thinking of intelligence, you might be thinking of, there are lots of different things that you might be thinking of, no link. Even if you do establish link, impacts on whether there's due cause, impacts on whether the owner of the brand can establish unfair advantage or detriment. It's just much more difficult in relation to that type of mark as it is in relation to one that has a higher level of inherent distinctive character. You might think, well, they're both just as well, they're arguably both just as well known, but actually the nature of the mark very much impacts on the assessment. And that's it. I'm mindful of the time, so I apologise for rabbiting on.
Thanks very much.